Can I have an off-the-record discussion with my ERISA long-term disability claims examiner? The long-term disability claims process, from beginning to end, is an adversarial process. The disability carrier plan is not in the business of paying you your disability benefits, and if they do, they're not in the business of paying you for any longer than they possibly can get away with. And you need to understand that. They may want to speak with you and they may try to be friendly with you. And what you should be doing is telling them that all communications with you should be in writing so there's no confusion about who said what about your claim. Now, many times a claims examiner, nurse, or other representative of the disability carrier plan will call you asking you for information. They're going to use your responses to deny or terminate your claim. And while they may tell you that they're there for you and that they have your best interests at heart, or that they could expedite the process if you would just confirm or clarify this or that, don't believe them. None of that is really true. If you ask to have an off-the-record discussion so that you can tell them all about your problems with your employer, with your family, with your financial situation, with your doctor, with your dog, with your cat, how you really are disabled, and how you would never ever file a claim if you could work, beware. Everything you say on the record, off the record, is part of your disability claim. There's no such thing as an off-the-record discussion in an ERISA disability policy or plan claim. Worse yet, this off-the-record discussion will be used against you directly or indirectly. The claims examiner may speculate about your motivation to have that off-the-record discussion. They'll even speculate about whether your social activities are inconsistent with what you tell your doctor or what you are capable of doing despite your activity of daily living forms. They may speculate that what you tell them is not consistent with anything, be it what you're telling the doctor, your medical records, your conversations with them, your forms, and guess what? That can result in surveillance. Now, you have to also understand that your claim is going to be reviewed by the plan's medical providers who's going to have access to the claims examiner's notes and speculation about your activity level and your motivation to remain disabled and your motivation or not to return to work. All of that speculation influences the medical provider. And having reviewed thousands of adjusting and peer review reports, I can tell you that all of this speculation can start because of your off-the-record discussion, what you told them during what you thought was a confidential, innocuous phone call. It's going to potentially result in a claims denial or termination. So don't be surprised if all of this speculation is shared with your doctor in an attempt to get your doctor to have them say that the opinions they've rendered in support of your claim are all based on your discussions with them, which contradict, of course, your discussions with the adjuster. And the doctor's going to be assumed that the carrier plan speculation is true, and then your doctor is going to be asked that million-dollar question to readdress their opinion about your treatment, your restrictions, and your ability to work. It becomes a tidal wave of speculation. So just don't have a discussion with your claims examiner and never, never ask for an off-the-record discussion. Ask them to put their questions in writing so that you can think about the answer, review your medical records, and give an answer that is not going to potentially result in either a delay in deciding your case, a denial of your claim, or a termination of your claim. Give me a call at 727-894-3188 if you have any questions about your ERISA disability claim. I can help you regardless of where you live in the United States. 727-894-3188.